Welcome back to the channel, and this one is going to have you talking. We're inside a Wexford County, Michigan courtroom where a man named Mr. McHenry is about to have the worst day of his year. Here's the setup. Back in June 2025, McHenry was arrested after his vehicle struck a house while he was under the influence of marijuana. Not a mailbox, not a fence, a house with people inside it. Neighbors were terrified. The original charges, operating while intoxicated, and an assault and battery case in a separate file. He got placed on bond with very clear conditions. No alcohol, no drugs, and that includes recreational marijuana, plus random testing. Sounds straightforward, right? Well, here's where it all falls apart. McHenry stopped showing up for his drug tests. September 22nd, no show. September 24th, no show. On October 1st, no show. He also missed his ETG alcohol test on 2 of those dates. And when the court finally gets him tested today, he pops positive for THC. He's been on bond since June 9th. It's now October. That marijuana should have been long gone from his system, unless he never stopped using. His defense attorney is going to try to explain it all away. His father passed away, he lost his ride to testing, he has limited resources. And honestly, some of that is genuinely heartbreaking. But the prosecution is about to remind everyone of a critical fact. This man drove a car into a house. The judge is going to wrestle with sympathy versus public safety and the final decision. It's gonna hit like a freight train. Stay with me through every second of this one because the ending is not what McHenry was hoping for.
Thank you, Your Honor. Taylor and Anna Prevention on behalf of Mr. McHenry, who is present at the council table.
Also, we are here for final pretrials on these matters, and in 252469 OD, the defendant has alleged bond violations that he failed to appear for a drug test as ordered on September 22nd, September 24th, October 1st, that he failed to appear for an ETG on September 24th and October 1st. Court had him tested today and he tested negative except for positive for THC. He was placed on probation and on bond in this file on June 9th with, among other things, the conditions of no alcohol and random testing, no drugs, including recreational marijuana and random testing. Is there any resolution to these cases at all?
Thank you, Your Honor. We do have an offer from the people of plead guilty to operating while visibly impaired in that file, and then the operating while intoxicated and the domestic violence in the other file would be dismissed. I'm sure Mr. Price can correct me though.
Yes, that is the offer.
We would still like to go forward with that today, if the court would so allow.
Did you say that the other file was a domestic and an operating while intoxicated?
No.
No, there is a 25-4015 SM is just domestic, and
It's an assault and battery.
I'm sorry, an assault.
And then the other is the drunk driving case.
Yes.
All right, okay. What are we doing with the bond violations? I should say, Mr. McHenry, you have the right to have a contested hearing in that matter where the prosecution would have to prove to the court that you did violate the terms of your bond, or you could plead guilty to those bond violations. If you want to talk to your attorney about how you want to proceed, if you haven't done that already.
We have discussed the
Okay.
issue, Your Honor. We would, if the court would want to, since we're ending a plea, we would plead guilty to the bond violations, but we would like to give a little explanation, not necessarily contest the fact that they did happen though.
Okay, so let's break down the deal that's on the table here because there's a lot happening at once. McHenry is facing multiple cases, an operating while intoxicated charge in one file, and an assault and battery charge in a separate file. The plea deal offered by the prosecution is this. He pleads guilty to the lesser charge of operating while visibly impaired, and in exchange, both the OWI and the assault and battery get dismissed. That's actually a significant reduction. Operating while visibly impaired is still a 93-day misdemeanor, misdemeanor, but the fine caps at $300 instead of $500, and it carries less stigma than a full OY conviction. On top of that, the defense is also agreeing to plead guilty to the bond violations, the missed drug tests, and missed ETG tests, but they want to offer an explanation. Oh, not a contest, just context. This is a classic defense strategy. Accept responsibility, but shape the narrative. The question is whether that explanation will be enough to keep McHenry out of jail, because right now he's standing in front of a judge with a plea deal in one hand and bond violations in the other, and those two things are about to collide.
All right, Mr. Carnes, I assume you don't have an issue with that?
No, Your Honor, that's fine.
All right, so. Did you put those on big sheets?
Yeah, I'm just trying to find jail credit.
Okay.
But the other one's getting dismissed, you only need one.
Right.
Okay.
Okay, so just so I'm clear, we're pleading to a visibly impaired, and then we're dismissing the assault case. And then we're gonna plead to the bond violation as well.
Yes, and the OWI would also be.
Right. Okay. Sir, have you heard what the attorneys have said the resolution in these cases are?
Yes,
And is that how you wish to resolve them?
yes,
Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
yes,
It's my understanding that in case number 252469 OD, you'll be pleading guilty to operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail and or a fine of 300. Wait a minute, is that? Yeah, and or a fine of $300. In exchange for that plea, the people will be dismissing the operating while intoxicated, which is another 93-day misdemeanor, but has a fine of not more than $500. Additionally, the case of 254015 SM, the assault and battery, will be dismissed. It's also my understanding that you'll be pleading guilty to the bond violations as well. Is that your full understanding of what's happening today?
yes,
Back on June 6th of this year, were you on probation or parole?
No,
You were on bond?
yeah,
All right. Do you remember reading and signing this advice of rights form, talk about your rights to a trial and your rights to an attorney?
yes,
Did you understand those rights?
yeah,
Most importantly, do you understand that you have the right to a jury trial and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
yes,
Other than the plea agreement, has anybody promised you anything?
no,
Has anybody threatened you in any way?
no,
And is it your own free choice to plead today?
yes,
Are counsel aware of any other promises, threats, or inducements that are not made part of the record?
no, Your Honor.
No, Your Honor.
Then, sir, to the allegation that on or about June 6, 2025, in the city of Cadillac of Wexford County, how do you plead to the added count of operating while visibly impaired?
Guilty,
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on June 6, were you operating a motor vehicle in the city of Cadillac?
yes,
And prior to operating that motor vehicle, had you consumed alcohol?
marijuana,
Marijuana?
yeah,
All right,
The alcohol test came back, Your Honor.
okay. Do you believe that that marijuana would have impaired your ability to operate a motor vehicle?
I think because I was on a new medication that I had an adverse reaction to, and because I didn't let myself figure out how I'd react to that medication, that I smoked the same day I started the medication, it definitely had an effect on me.
Now this is where the details get really interesting. McHenry admits he smoked marijuana from a high concentrate THC cartridge, not a joint, a cartridge, which delivers significantly more THC per hit. And he did it on the same day he started a brand new medication. He didn't give himself time to see how the medication would affect him. He didn't give himself extra time after using a stronger form of marijuana than he was used to, and then 5 or 6 hours later, he got behind the wheel. And we already know where that drive ended. into the side of a house. Now his attorney actually jumps in here to add a critical detail. McHenry knew the cartridge was higher concentration than what he normally used, and he still didn't give himself more time before driving. The judge and the prosecutor are essentially building the factual basis for the plea right now. McHenry isn't just admitting he drove impaired. He's admitting he made a series of bad decisions that compounded into a dangerous situation. This is exactly the kind of testimony that will matter at sentencing. Every word he says right now is on the record.
How soon prior to operating the vehicle had you smoked?
It was like 5 or 6 hours prior to driving.
Okay. Ms.
If I may as well, Your Honor.
Yes.
You also took a marijuana product that was higher concentrate than what you would normally take that
Yeah,
day.
it was a concentrate cartridge rather than just smoking a joint, which is the higher THC content.
And you knew
So-
it was higher,
Yeah,
and you didn't give yourself more time.
no,
So when you say you smoked, was it a joint or a cartridge or both?
it was a cartridge.
So, okay, all right. Do counsel believe the defendants provided the factual basis to accept the plea and the court rules have been complied with?
Yes, Your Honor.
Yes, Your Honor, we would ask the court acceptably.
As does the court, I find the plea is knowing, voluntary, and accurate, sir. I find you guilty of operating while visibly impaired pursuant to the plea agreement, the operating while intoxicated, and the assault and battery case will be dismissed. Now then, turning to the bond violations, sir, how do you plead to that you failed to appear for a drug test as ordered on September 22nd, September 24th, October 1st, and that you failed to appear for an ETG on September 24th and October 1st?
I plead guilty to that with the.
Okay, hold on. I know you want to explain it, but I've got a process I got to go through, all right? So back on those dates, did you know that you were supposed to test?
Yeah,
And did you not test on those dates?
I did not test.
And how was it that you knew that you were supposed to appear for both the drug test and the ETG?
Because my number came up on the Facebook page for community corrections in Wexford County.
Okay, and you knew it had come up
Yeah,
and you did not appear on any of those dates?
So McHenry just pled guilty to the bond violations, and the way the system works here is actually kind of fascinating. In Wexford County, defendants on bond who are required to do random drug testing check a Facebook page for community corrections. Their number comes up, they go test. Simple. McHenry admits his number came up on September 22nd, 24th, and October 1st. He saw it, he knew, and he didn't go. Not once. Not on any of those dates. Now, notice how the judge had to pump the brakes when McHenry tried to jump straight into his explanation. Hold on. I know you want to explain it, but I've got a process I got to go through. The judge needs to establish the factual basis first before any mitigating explanations come in. That's proper procedure. The admission has to be clean and unambiguous on the record. McHenry saw the requirement, I understood the requirement, and didn't comply. Period. Now the real question is, what happens next? The plea is done. The bond violations are admitted. But sentencing can't happen today because of a paperwork issue. So the judge has to decide what to do with McHenry's bond in the meantime. And this is where things are about to get emotional.
no,
All right. The court finds, well, counsel, do you believe the defendants provided a factual basis?
Yes, sir.
Yes, Your Honor.
All right. So we can't, well, I assume we can't sentence today because we don't have a substance use assessment, correct?
We do have a completed assessment, Your Honor.
Okay.
I do apologize, Your Honor. I had copies I have one copy in my file. I thought our social worker had already sent that over to Mr. Carnes. I could run an extra copy of it right now, or.
Well, the court doesn't have time to do one right now, given the docket that I still have to go through. So what we'll do is we'll put this over, we'll set this for a sentencing.
All right. I do apologize. I know that already been sent to the prosecutor.
So now I have to decide what to do with Bond because he has tested positive for THC. He hasn't tested. So
If I may provide a little additional
You may.
allocation, Your Honor. Obviously, it is not excused, but a major contributing factor for the bond violation was the fact that Mr. McHenry's father passed away on September 21st, is my understanding, or early in the morning of September 22nd. His father was the main person that would help him transport to and from testing and would also cover the cost. He has very little resources. Without that support, he really struggled to get to and from testing as he needed to. We would also emphasize again, Your Honor, this case all started with an allegation of alcohol. No alcohol was found. There appears to have found in his system. The marijuana is obviously still an issue and still the basis for the plea. But we would respectfully request, especially if the court is not able to go forward with sentencing today, that the court allow him to reinstate his bond with a no marijuana and no driving provision and some sort of additional testing the court sees fit in consideration of his extremely limited resources and other struggles. It sounds like he is taking the necessary steps where he can to make sure that he has adequate supports in the community. And we would just ask that the court would take all those into consideration. Also, the fact that even though we have had bond issues, he has appeared at all.
This is the moment where the human side of the courtroom really comes through, and I want to be real with you all for a second. McHenry's father passed away on September 21st, the day before his first missed test. His dad was his primary transportation to testing and was helping cover the costs. Losing a parent is devastating under any circumstances, but losing the person who was literally your lifeline to staying compliant with the court? That's a crushing blow. The defense attorney is making a compassionate, well-structured argument here. Yes, the violations happened, we're not contesting that, but the context matters. He also points out that McHenry has appeared at every single court hearing and has been cooperative with staff and officers. He's asking the judge to reinstate bond with stricter conditions. No marijuana, no driving. On additional testing, rather than locking him up before sentencing. And he makes an interesting legal point too. The original case started as an alcohol allegation, but no alcohol was found in McHenry's system. It was marijuana. Now, does any of this excuse the bond violations or the continued THC use? That's for the judge to decide, but I want to ask you, if you were the judge, would the death of a parent change how you handle this? Let me know in the comments.
Court hearings and been cooperative with staff and the officers when. Thank you.
Thank you. Mr. Carnes?
Thank you, Your Honor. This is a concerning matter for the people in the underlying case. Mr. McHenry's vehicle hit a house, and it didn't hit it hard. It didn't cause damage to the house. It caused damage to the yard. It did actually.
I'm sorry, I can't hear you, Mr. Carnes.
Mr. McHenry's in the underlying file. Mr. McHenry's vehicle hit a house. Didn't hit it hard, but he made contact with it, and there was damage to the yard. Obviously, the occupants of the house and the neighbors were quite scared. So this is concerning behavior, and then it's concerning that he's still testing positive 4 months later. I would ask the court to remand Mr. McHenry pending sentencing, which I would imagine we did too.
Mr. McHenry, first of all, I apologize for your loss. I did see that in the paper and I apologize for that. Were you still living at the Avon Lane Road or Avon Lane?
That's my mailing address. I live in Lake City, so the commute to the drug house was difficult when my father passed.
Okay. Well, the court's in a tough spot because you hadn't tested as you had been ordered to do. You also had prior violations that you had failed to appear for a test on the 30th of August and that you had failed to enroll in testing. I know that all got taken care of, but well, I might be able to, I don't want to say forgive, but maybe overlook the mistests. I can't overlook the fact that you're still testing positive for THC. That was very clear that the court had ordered no marijuana. And clearly, you've been on bond since June 9th. That certainly should have been out of your system by now if you had stopped.
And right there, that's the moment the temperature in the courtroom shifts. The judge starts by expressing genuine condolences for McHenry's loss. He even mentions he saw the obituary in the paper. That's not a judge being cold or dismissive. He's acknowledging the pain, but then he draws the line, and he draws it clearly. I might be able to overlook the missed tests. I cannot overlook the fact that you're still testing positive for THC, and his logic is airtight. McHenry has been on bond since June 9th. It's now October. If he had stopped using marijuana when the court ordered him to, THC would have cleared his system weeks, potentially months, ago. The fact that he's still testing positive means he never stopped. Boy, and the judge connects it directly to the underlying offense. I've got somebody who drove a car into a house under the influence of marijuana. That's not just a legal observation. That's the judge telling McHenry and everyone in that courtroom exactly where his mind is heading. The sympathy is real, but the public safety concern is winning. You can feel the ruling coming. The prosecutor has already reminded the court that people were inside that house and neighbors were terrified. This is no longer about missed tests. This is about a pattern of behavior that puts people's lives at risk.
So that tells me that you haven't stopped. So I've got somebody who drove a car into a house under the influence of marijuana. Mr. Carnes, what was the lab result on that?
Your Honor, it was 22 nanograms per milliliter of the active THC, as well as 5.4 nanograms per milliliter of 11-hydroxy delta 9, which is a metabolite, but it's a metabolite that disappears within an hour. So I did speak with the lab technician on this. She was prepared to testify that is extremely recent use.
Sir, I don't want to say I'm sorry because you did it to yourself. No.
I
No,
just want to.
no, you had your, no. Sir, I'm going to remand you to the custody of the Wexford County Sheriff's Office. Bond is revoked. Court next calls.
There is an assessment and we're looking at the timeline. Do you want to miss it? Or should we try to do that Monday night or not?
Squeeze it in.
Monday? Okay.
Well.
And just like that, bond revoked, remanded to custody. Mr. McHenry is going to jail today. Let's take a step back and look at the full picture of what just happened in this courtroom. McHenry came in facing an operating while intoxicated charge and an assault and battery charge in a separate case, plus multiple bond violations for missed drug tests and ETG tests. His defense team secured a plea deal that reduced the OWI to operating while visibly impaired and got the assault and battery case completely dismissed. On paper, that's a win for the defense, but the bond violations and the positive THC test undid everything. The judge heard the mitigating factors, the death of McHenry's father, the loss of transportation, the limited financial resources, and he acknowledged them with genuine empathy. He even said he might be able to overlook the missed tests, but the continued marijuana use was the line he could not and would not cross. The prosecution hammered home the critical fact. This defendant drove a vehicle into a house while impaired, scared the occupants and neighbors, and 4 months later is still using the substance that caused the incident. The lab results sealed it. 22 nanograms per milliliter of active THC and 5.4 nanograms of 11-hydroxy delta 9, a metabolite that disappears within an hour of use, meaning McHenry had used marijuana very recently. The judge's final words say it all. I don't want to say I'm sorry because you did it to yourself. This case is a powerful reminder that the court system can show compassion, but compliance is non-negotiable. You can grieve, you can struggle, you can face hardship, but if the court tells you to stop using a substance and you don't, especially when that substance is the reason you're in court in the first place, there are consequences. McHenry will now await sentencing from behind bars. If you found this case as thought-provoking as we did, make sure to hit that like button. Share your thoughts in the comments. I really want to know, do you think the judge made the right call? Should he have given McHenry one more chance given the circumstances? Don't forget to subscribe and hit that notification bell for more courtroom breakdowns just like this one. We'll see you in the next one.